guys, good morning. What are you discussing today?
Good morning. We are just discussing about our assignment, and it is all about the case.
So what case is it?
It's about Kohler versus Cerebus case.
Oh, we are also looking about the case. Is that about the negligence here?
Yes, basically what happened was that Miss Kohler, who is a defendant, worked for Cerebus as a sales representative at first until she was retired. But later, she was rehired as a merchandising representative on a part-time basis. The letter of an engagement between them set only the bare bones of the contract of employment. It stated her starting date and her work week was Monday to Wednesday. The letter confirmed her salary structured as a particular hourly rate. A car allowance is stated amount per kilometer and said that out-of-pocket expenses to support accidental expenditure apply. However, this agreement of engagement did not mention about the duties she was expected to perform. After knowing of her job responsibilities, she clearly mentioned that it was too much of her. Her supervisor told her to try it sometime, and after that, if she was unable to cope, then to inform him.
Also, did she report her difficulties to her employer, right?
The plaintiff did mention both orally and in writing about her workload, but there was no response from the defendant. 5 months after starting her job, Miss Kohler got it ill. Initially, a physical disorder was assumed, but additional consideration disclosed to Miss Kohler was suffering from a recognizing psychiatric illness called fibromyalgia syndrome, which had been caused by her work. Appellant claimed that her psychiatric condition had been caused by the breach of an implied term of her employment contract or a breach of statutory based on the Occupational Safety of Health Act 1980 for Western Australia. In accordance to the practice of such claims, the action was tied largely to the basis of the alleged breach of common law duty.
So as far as I know, the appellant didn't do it right. So did you guys agree with the statement made by the court?
Well, you see, the court decides based on facts. And breach of duty of employees under Section 19(1) of the Occupational Safety and Health Act 1984, which clearly states that an employer shall, so far as is practicable, provide and maintain a working environment in which his employees are not exposed to hazards and in particular, but without limiting the generality of the foregoing. To begin with, the business drawing in the work to perform expressed obligations is qualified for acceptance without apparent signs causing of likelihood of a psychiatric harm. That is, that the representative considers that he or she can carry out the employment, suggesting some capability upon what generally is explicitly specified by the agreement would repudiate essential standards. Besides, looking to qualify the operation of the agreement as a consequence of data the business later procures about the weakness of the worker to psychiatric damage would be no less conflicting of the fundamental guidelines. And the commitments of the gatherings are settled at the season of the agreement unless and until they vary. So there are 2 warnings that has to be present. First, up to this point, we have indicated just the business execution of the obligations initially stated in an agreement of the job. It might be that diverse contemplations could be said to interrupt when a business is qualified for different the obligations to be performed by a representative and thus as such. The activity of forces under an agreement of job may all the more promptly be comprehended as subject to capability on their activities, then with the emphasis on execution of the work for which the gatherings stipulated when making the agreement for the job. Furthermore, we are not to be comprehended as disposing inquiries concerning development of the agreement of the livelihood. Distinguishing the obligation to be performed under an agreement of business and specifically recognizing whether execution of those obligations is liable to some inferred capability or confinement fundamentally requires that full investigation of the legally binding position of which Lord Roger talked in Barber versus Somerset County Council against the important statutory structure in which the agreement was made. For this situation, it is not important to consider any issues that may be displayed by variety of the obligations for which party initially stipulate in an agreement of occupation in the light of the fact that for this situation there was not said to have been any variety of the appealing parties' obligations.
Well, the evidence revealed that the appellant was a very consensus employee. She may well have done more than her contract of employment required of her, but the employer did not vary her duties from those originally stated, or those she has
when she
done
was,
before.
engaged
And
with.
when she will re-engage as part-time merchandising representative. And as the appellant's complaints to her employer reveal, it was the performance of those duties which she found to be more than she could cope with. Nor is it necessary to decide this case on the basis that the appellant's agreement to perform the duties which were a cause of her injuries is conclusive against her claim. The identification of the duties for which the parties stipulated would require much closer attention to the content of the contractual relationship between them than was given in the evidence and argument in the cause. For present purpose, it is sufficient to notice that her agreement to undertake the task stipulated runs contrary to the contention that the employer asked reasonably to have appreciated that the performance of those tasks posed risk to the appellant's psychiatric health.
So to conclude, we can say that the employers had no reason to suspect that the appellant was at a risk of psychiatric injury in the region upon which the full court conclusion hinges. Here, there was no indications of any particular vulnerability of the appellant. As noted earlier, she made a complaint to her superior, but none of them suggested that her attempts to perform the duties required of her were putting or would put her health at a risk. She did not suggest at any time that she was vulnerable to psychiatric injury or that the work was putting her at a risk of such an injury. None of her many complaints suggested such as possibility. As full court said, her complaints may have been understood as suggestion in an industrial relations problem. They didn't suggest danger to her psychiatric health. When she did go off sick, she thought that the illness was physical, not psychiatric, and there was therefore in these circumstances no reason for the employer to suspect risks to the appellant's psychiatric health. The full court was right to conclude that the employer was not shown to have breached the duty of care, so the appeal to this court should be dismissed with cause.